So let me introduce to you Brigid Clark, who's head in Sydney of the team here for employment, safety and migration. Brigid has extensive in-house and external lawyer experience in these areas and is often called upon to present to national and global businesses on these matters within both the public and private sectors on the full spectrum of employment, industrial relations and work health and safety matters. My favourite Brigid quote is direct from the website. Employees are a company's most valuable asset. I work with my clients through the life cycle of the employment relationship to achieve the best outcomes from a commercial risk, reputational and human perspective. We work with Brigid often. She provides great support to the PLN team with our national and international businesses doing work in Australia and in the Pacific and elsewhere. Brigid regularly advises clients on all aspects of the employment relationship, including conducting and advising on complex workplace compliance issues and workplace investigations, managing ill and injured workers, as well as advising on termination of employment discrimination, bullying and harassment issues. And Brigid, interestingly, is also a former prosecutor, so beware. And with that and those kind words, I'm delighted to hand over to Brigid for our final presentation this year. I look forward to talking to you all at the end of the presentation. Brigid.
Thank you, John. Thanks, everybody. Before we start, I just wanted to acknowledge the traditional custodians of the land on which we're all meeting today, whether you're in Australia or in the Pacific. We are on Gadigal land here in Sydney, and I recognise and pay my respects to elders past, present and emerging. So as John mentioned today, we're just going to do a bit of a touch on a few sort of hot topics in employment law and developments over the last little while in Australia and things you might need to be thinking about, particularly for global businesses. So a few touch points on some emerging issues in the introduction of AI into the workplace and also looking at some recent amendments to Australia's Fair Work Act, which is our national piece of industrial relations legislation, including some changes to the definition of employment in the Fair Work Act and looking at how that impacts whether somebody is an employee or a contractor. And then we'll touch on briefly the right to disconnect laws, which some of you may have heard about. We've had them in Australia for a couple of months now, so and it's not something that's purely in Australia. There are other countries that do have similar laws, but I'll just touch on what the Australian law says and some of the impact in relation to workplaces, particularly in a global work environment. So starting off with the AI, some of the trends and issues that we're seeing in workplaces in Australia. I think, we all know that AI is going to be, putting a significant change on the way we do our work, the way we perform work and the way we deliver work in the future. So these are some of the things that obviously a number of businesses are grappling with, not just from a workplace and employment perspective, but obviously other aspects, privacy, data, IP. But I think from a workplace or labour perspective, some of the things that businesses are grappling with is, with the implementation of AI. So looking at, how occupations will be affected. How are we going to change the way we do our work? I think a recent McKinsey study in Australia showed that at least 10%, if not more, jobs will change rapidly or won't exist in the next, between now and 2030. And look, that's probably a fairly conservative figure. I think, 10% of jobs may no longer exist by 2030, but probably a lot of our jobs are obviously going to be impacted and will change rapidly with the adoption and implementation of AI. So these are the types of things that obviously all businesses are grappling with, and the government has obviously been grappling with this as well, the Australian government. So what this means for how we design jobs and how we make decisions about our workforce. So some of that leads to how AI is currently being used, and obviously there's a large spectrum of AI, and depending on the nature of the companies you're working in, obviously some are far ahead and really advanced in this space, and some are quite far behind. But in time, obviously most businesses will use AI in one way or another. So some of the things that have been talked about, and this comes from some recent discussions within Australia. We had a Senate committee investigation into AI recently. I'll talk about that in a moment. But some of the issues that are being debated here in Australia include the lack of transparency. So at the moment, there's no requirement for companies or employers to disclose how they're using AI. Or if there's a problem in how these technologies are being used. Now, of course, a lot of businesses are starting to use AI from the beginning of the employment relationship. So, for example, there's been a lot of discussion about the potential for AI tools to reduce bias in like hiring decisions, for example. Now, the best example of this was, and look, we know AI systems are developing, but the best example of this was with Amazon. So a couple of years ago, Amazon decided to use AI systems to filter employees who were applying for jobs. And they used an AI tool to try to remove bias in terms of unconscious bias and to look at the applicants. Now, the funny outcome with that case was that the data that Amazon used in that recruitment tool relied on the input of data that Amazon had used for the last 10 years. And they were looking at roles for data scientists, which were heavily male-based roles. So perversely, they used AI thinking it would cut out some discrimination issues. But in fact, because of the input they used into their tool, it had the opposite effect, where the AI tool actually was quite discriminatory. So I guess there's some of these things that AI is only as good as the information that you put into it. So while there's a lot of opportunities, there can be risks associated with it as well. One sort of more recent development we're seeing in Australia is the idea that AI can impose intrusive surveillance of workers, and that can be a workplace health and safety risk. That's a whole other topic for today. I'm only just going to spot a few issues and a few points of discussion, but these are the types of things we're debating in Australia at the moment. And particularly with the industrial relations system in Australia, we do have quite heavy union involvement. They've gone some unions are even suggesting a total ban on using AI to hire, fire, or discipline and promote workers. So, we look to some of the examples here in Australia, but we look to some of the examples overseas. And one of the examples that the unions in Australia have cottoned on to is this issue of Whole Foods. Now, for those of you who have ever travelled to the States, or you've probably heard of Whole Foods, it's a huge supermarket chain over in the US. It's actually also owned by Amazon. I don't mean to be picking on Amazon, but I feel like I don't mean to be doing that, but they're obviously quite advanced with their AI and use of AI. So in the US, Whole Foods were using AI and the data they were using to actually try and pick out hotspots within its business where people were either unionised, or they were looking at things like employee loyalty, the turnover rates, the racial diversity of their workforce. So they were using it for both, I guess, some good things, looking at, if there's a high turnover rate or there's a lack of diversity in a particular store or a particular region. But I guess the point being, they use this sort of as a tool to test what their workforce is doing and some of the trends within their workforce. So it's obviously a really interesting developing area that touches on, the makeup of our workforces, how we do our work, what data we're looking at, and some of the decisions we're making. And part of the challenge, I suppose, with some of this is that at the moment we don't have specific legislation in Australia, but I think we will be moving towards a regime where there probably will be some more regulation around AI in the workplace. And to that end, Australia has actually implemented, and these are voluntary principles, but we've actually got some AI ethics principles, and these are, broadly speaking, these are 8 ethics principles, as I said, that have been designed by our Department of Industry, Science and Resources to ensure AI usage is safe, secure and reliable. So obviously, as I said, these ethics principles is completely voluntary, but it provides an ethical framework for the use of AI, broadly at work or in organisations. So I think the first two are sort of ones I wanted to touch on really with that human, societal and environmental well-being. So the idea that any AI system should actually benefit individuals, workers and customers and the people we're dealing with, and have human-centered values. So the actual keeping the human context at the centre of everything we do. And obviously fairness is part of that as well as privacy, protection and security. The other principles relate to the reliability and safety of the tools we're using, and transparency, as I sort of mentioned it before. Some of the current things we're debating is that organisations may well use AI, but it's not completely transparent to clients or workers how we're using it from day to day. So this all led to in Australia, the Senate committee looking at some of these challenges and opportunities with AI. And the Senate committee was tasked over a period of, I think it was most of this year. The report was meant to come out in September. It actually ended up being extended out to November. And the Senate committee came up with 13 recommendations about the implementation of AI in businesses in Australia. These are just three of the recommendations that relate to employees and the workplace. The other recommendations deal with things from privacy to IP and other impacts of AI. But these are the three of the 13 recommendations the government came up with. So the first one being that, again, that picking up that theme from the AI ethics principles, that AI, the definition of high-risk AI clearly includes the use of AI that impacts on the rights of people at work. So if we're using AI tools to either hire, make disciplinary decisions through the employment relationship or through or terminate the employment relationship, that people are thinking about the rights of people that have in the workplace. The other thing that's an interesting development is the government's actually recommended that we extend our existing workplace health and safety laws in Australia to deal with workplace risks that are posed by the adoption of AI. Whether we will, because there's a risk management framework already legislated in those laws, I think that will be one very interesting area where those laws are being potentially expanded in the future. And the third one is that the government recommends that all workers, worker organisations, whether they're employees, employers, unions, etc., anyone that represents employees is thoroughly consulted on the need for and the approach to any regulatory responses looking at the impact of AI on work and workplaces. So go away and read the report if you're interested. It's 222 pages. We will be putting out some more, an article, hopefully before Christmas.
A summary.
Summary for 222 pages. So look out for that. I'll make sure that John can share it on the PLN network if it's of interest, because, as I said, and we'll be looking at it from not just the employment workplace perspective, but also the sort of IP data aspect as well. So look out for that. So look, that's just a very quick snapshot of some of the many issues we are seeing in Australia, some of the trends with the use of AI. But obviously, the key issue here is, if you are using AI, be thinking about how that impacts the work you're doing, and particularly with your employees. Do you have policies and procedures and governance frameworks to deal with AI? And obviously, you're going to have to keep on top of these over the next coming years, because the pace of change will probably be quite significant, with potential legislative change as well. So it's sort of a watch this space. And for those of you in the Pacific particularly, or have workforces in the Pacific, I think, John, sometimes you say they're usually a few years behind Australia in terms of the legislation.
Yeah, I mean, a lot of the legislation that ends up in the Pacific has its genesis in Australia or New Zealand. I mean, usually. So these things, while some of the areas might not be there today, they're certainly being discussed out there by employers and employees across the region. So yeah, I think it's sort of a watch this space thing is exactly right.
Yep. So not much to absorb there, but yeah, there's just, as I said, just a real snapshot of some of the things that have been happening over the last few months in Australia. So watch this space.
the Whole Foods example you gave with Amazon, were they criticised for using that data in that way, or is it just an example of the use of the data?
They were criticised for sort of having a heat map about where there might be union activity from workers. So from an industrial relations perspective, but honestly, I think, the tracking of, staff turnover or racial diversity in certain workforces, large workforces that are, all across a very large company, yeah. I think that can be a really good thing. So they were criticised, but mostly for that unionised sort of heat map, they called it. So
sorry,
that's okay. Did anyone have any other questions online before I move on to the next topic? I'll press ahead because we've got only a short time for today's session. So the next, I guess, hot topic, or something we've seen changed in Australia in the last 6 months, is something that's sort of old but new again. So what happened was, a couple of years ago, there were two high court cases in the Australian High Court dealing with the issue of who is an employee versus who is an independent contractor. So there hadn't been any cases going to the High Court on this issue for many, many, many years. So there were two decisions, one in personal contract and one in JAMSEC. Now, the decisions of the High Court really focused on looking at the nature of the relationship based on the written contract between the parties as to whether the relationship was one of employment or one of true independent contracting. So it was a bit of a shift in the common law up to that time. But what's happened since those decisions came into force is that we had a change of government a few years ago when Labor came into force. The Labor government has been quite prolific in changing industrial relations and employment laws in Australia, particularly with the Fair Work Act. There's been a raft of changes you might have heard of, the closing loopholes provisions and many changes to the Fair Work Act. Now, only one of the many changes, and this is a change that came into force in August this year, was actually putting in a new definition of employment in the Fair Work Act. So before this provision, the Fair Work Act dealt with the definition of employee and employer based on their ordinary meaning of the word. Now, this is the same case. So the definition has changed, but it just codifies what the situation was. So basically, whether a person is an employer or employee is to have regard to the ordinary meaning of those words, but has to be determined by looking at the real substance, practical reality, and the true nature of the relationship. Now, what does that mean? Okay, so the ordinary meaning is what is an employee and what is an employer, looking at the years and years we have of common law. So the courts have looked at these issues for many, many years. The only difference with this definition is it says, well, now you must look at the ordinary meaning, so having regard to that common law of all those years. But instead of just focusing on the contractual terms between the parties, which is the outcome in personal contracting and JAMSEC, you have to look at the nature of the relationship. So what does that really mean in practice? Well, when you're looking at whether somebody is a true independent contractor or an employee, you have to go through a number of factors to consider whether they are, and we do in the Fair Work Act have what's called sham contracting arrangements. So there are penalties if the nature of the relationship is truly one of employment, but it's framed as one of independent contracting. Employers can be liable because, if it's seen to be a sham arrangement, so that employers can get out of paying employee entitlements such as annual leave, sick leave, those sorts of things. So that's the context and why it's sort of, I guess, quite important to get this right. So the key factors, and this is not new, this concept of what you need to consider. It's just that, as I said, the definition has changed and it's sort of changing what the High Court said in those two cases to a degree. So you still really need to look at not just the nature of the relationship. So looking at the degree of control that an employer has over the individual. Do they have a high degree of control where that person must come to the office every day? They have to wear, the company branded uniform? Do they bring their own tools and equipment, or are they using solely the equipment of the company? One of the key things to look at is whether the person has the right to delegate the work to somebody else. And that will be, if they do have the right to delegate to a third party to do the work, that will be more akin to a relationship of contractor and principal, as opposed to one of employment where you're at the sole, really at the control of the employer that's employing you and paying you to turn up every day. The other thing is exclusivity. So a true independent contractor will be one that may work for 5 or 6 different businesses or 2 different businesses at any one time. They might be doing a project for one company for a short period of time on a contract basis. So that's not to say that you might have part-time employees who do have second jobs. That can still be one of employment, but it just really looks at whether that person is working exclusively for your business. If they are, then it's more akin to potentially employment relationship than a contracting one. Also, the method of remuneration. So obviously, if you're paying somebody a salary, that's going to be an employee. But if they're a true contractor, they will be invoicing you on an hourly or project related basis and then charging GST, for example. So those are some of the factors you need to consider when you're looking at whether somebody is an independent contractor or an employee. And those things aren't particularly new, but it's just that the change in the approach under the Fair Work Act has changed. One of the other key things that has changed is the implementation in the Fair Work Act of an opt-out regime. Now, this provides that an independent contractor who earns over what's called the high income threshold for contractors, that's currently been set as an amount of $175,000 Australian dollars per annum, can opt out. So what that means is basically they want to stay as an independent contractor, despite the fact that if you looked at the true nature and practical reality of the relationship, they would, for all other intents and purposes, be an employee. Now, either the principal company or the potential, the principal who's contracting or the employer can issue an opt-out notice under the Fair Work Act. The key thing to note is this only applies in relation to sole trader individuals. The way that these provisions are drafted are in such a way that they don't actually apply to contractors who are contracting through a proprietary limited company. It only really applies to individuals who own over that high income threshold. So the ability to issue these opt-out notices is actually quite limited in practice. I've had a few clients that have come and asked questions about this, and then they've kind of realised that, well, they're either probably an employee, or unless they really want to be a contractor, they don't meet the criteria. For example, they're not being paid above the high income threshold, or otherwise they're contracting through a corporate vehicle, and therefore they're not going to be, these opt-out notices are not going to apply. So there's a lot of, I won't go into all the details of what's required in the opt-out notices, but just to note that these provisions do exist, and they certainly can assist with, if you are engaging sole trader individuals as contractors, and they want to stay as contractors. It gives that ability to sort of say, well, we don't, we want to opt out of being an employee if we want to be a contractor. So it gives some more practical, I guess, options to these kind of sole traders. So,
is that aimed also at like particular industries, like from mining, sort of fly-in, fly-out people, or airline pilots and those sorts of situations?
No, I don't think they've sort of. It's not. I don't think they've implemented it for particular industries necessarily. I think it's more just the fact that a lot more people now, I think with the gig economy and those sorts of things, those sorts of arrangements where they've looked at, Uber drivers and whether they're an employee or a contractor, and it just gives that ability for particularly those high income, and I don't, they've said it obviously for the high income people that want to be contractors because it's more beneficial to them, and they know their rights, and they're like, well, I'm not going to get paid annual leave or sick leave or all the entitlements I would get if I was an employee, and they want it that way. So
sure, because they've got other arrangements.
That's
like
right.
Income splitting or
Yeah, whatever it might be. So look, it's a pretty niche. I don't think there's a huge amount of take up. I certainly haven't seen a lot of businesses implementing this, but it's an interesting sort of development that some people haven't heard about. And also there's been a bit of a confusion about that piece of the fact the way it's being drafted is individuals, not corporate entities.
On the previous point, just in relation to the changes to the Fair Work Act and the High Court cases, I mean, for overseas businesses which rely on Australian jurisprudence, like decisions from the High Court, their interpretation of the employment contracting sort of dichotomy is still stands true. I mean, the High Court decision is still instructive in those areas for countries which adopt that sort of line of case law. So we're sort of ending up in a position where there's High Court decisions which say one thing, and then there's a carve out in Australia or a difference in Australia, in inverted commas, in the legislation. So,
and it's really actually that difference that, you know, the changes in legislation are kind of going back to the case law that was pre-personal contracting and JAMSEC. So you still, I guess, for those businesses, for the businesses in the Pacific, you'd probably want to have regard to all of those criteria as well as the contract, which is the sort of position that personal contracting and JAMSEC highlighted, that the contract sort of really guided the nature of the relationship. So you want to be thinking about it holistically, really, contract and also the practical terms.
And to be aware of the difference.
And just, to be aware of the difference and the implications for getting it wrong. The final topic I just wanted to touch on very briefly, we don't have long, is just the right to disconnect laws. So as I mentioned at the outset, these are not new laws in the context of other countries. So France has these kind of laws, Italy, Mexico, Spain, there's a couple of others, I haven't listed all of them, but these are laws that basically were implemented again with some of the other Fair Work Act changes on the 26th of August 2024. Currently apply to all businesses apart from small businesses. So in Australia, businesses with less than 15 people have a grace period. They don't have to comply with these laws until 26th of August 2025. But basically the laws are providing a right for employees to refuse to monitor, read or respond to contact from their employers outside of their usual working hours, unless it's unreasonable. So some of the considerations will be whether it's reasonable or not, why they're being contacted. If it's part of their job that they know they're going to be contacted out of hours from time to time, then that's going to be, it's going to be expected that they will respond. But what businesses need to just keep in mind is how the contact's made, what type of disruption is caused to the employee, the nature to the extent the employee is compensated. So if they're a high income earner, there is some expectation that there might be a need to contact them out of hours and they may need to respond from time to time based on their compensation and the role and responsibility they play in the organisation. The other thing is their personal circumstances. So if they've got carers responsibilities outside of work, that will be a factor as to whether it's reasonable or unreasonable for people to respond, I suppose. I guess the key point here is just to think about if you do have workers in Australia or you're operating in a global environment, consider if you do need to contact someone outside of reasonable hours. Now, obviously, that's difficult. If you're working in a global environment, you've got people emailing from all across the globe in different time zones. It's just to be aware that these laws now exist and workers can bring a dispute, although they're meant to be dealing with the dispute in the first instance with their employer. So if they have a dispute about a right to disconnect, they have a right to go and talk to the company and say, look, I've got this dispute. If it's not resolved, then they have a right to go to the Fair Work Commission to try to resolve that dispute. But basically, as I said, out of hours contact is still going to be considered reasonable in Australia if the worker's paid to be on call due to the nature of their job. The job description requires them. So just thinking about when you're engaging people, what do they do? Do they need to be contacted? Is it an emergency? Is there someone that needs to be contacted because all of a sudden, they're meant to be at a site at 7 o'clock tomorrow and they no longer need to go, so you need to contact them and let them know. Like all those kind of practical, logical reasons. But just to be aware, as I said, if you are contacting employees in Australian businesses, there's this right that employees now have. And I think it's really just to capture some of those badly performing businesses that would unfairly harass and expect people to work, outside of hours without being properly compensated. And there's not, these days, there's not too many of those floating around, but you'd still be surprised we do get. There are some interesting questions that come our way about this. So that's just a quick update on what the law is about. Just keep it in mind.
I suppose it's a bit of a challenge for Australian businesses who have employees under Australian law contracts who aren't working in Australia. And we've got lots of clients who have people working for, they've got an Australian contract, but they'll get seconded or placed with a subsidiary or a branch in another country. And in all those sorts of different situations, I guess they've got to be across those requirements and the issues that arise out of those, and consider those in the local context as well, and time differences, and all that sort of stuff. So it gets pretty challenging.
I think that's right, and I think that thing to think about that is, in a lot of our Australian law contracts, we will say, you may have to work reasonable additional hours, right? So outside of your contracted hours from time to time. But the other thing is just to think about, if you have job descriptions for that person when they're working in global businesses, to think about just putting in there, you may need to be contacted outside of hours, or you may need to be on phone calls from time to time outside of hours because you've got a phone call with a global stakeholders. So it's just thinking about some of those practicalities, I suppose, to deal with that.
Yeah.
That's all we had time for today, but happy to stay online, obviously, and answer any questions, whether through the chat or if you want to come off mute, please go ahead.
There's a QR code on the screen there if you want to get in contact with Brigid, and we very much appreciate her time today. If anybody else does not have any other questions, then we'd like to say thank you again for joining, and we'll sign off for 2024. Look forward to many more of these presentations during the course of next year. Everybody have happy holidays, and we'll see you in 2025.
Thanks, everybody.
Thank you.
Bye.